proceeds have been listed before the Honorable Chief Judge and Associate Judges now presiding on the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and His Honorable Court. The Honorable Court now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. You will have the distinction of being our first oral arguments of this term. So welcome. Apologize that we're starting just a few minutes late. We have two matters set this morning on the calendar. The first of which is VORNADO 3040 M Street LLC versus District of Columbia. Counsel, are you ready to proceed?
Yes.
I should say as well, I neglected to say I'm joined this morning by my colleagues, Judge Steele and Judge Howard.
Good morning. May it please the court. William Bosch on behalf of the appellant, VORNADO 3040 M Street LLC. I'd like to reserve 5 minutes for rebuttal. VORNADO seeks a refund of transfer and recordation taxes paid in connection with an intra-corporate merger of a wholly owned subsidiary into its direct corporate parent. This case is unlike the other transfer and recordation taxes this court has recently wrestled with, like the Design Center case.
Can you tell us why?
And
we'll just go straight to that, Counsel.
This matter does not involve a direct conveyance of property to a new owner. There was no contract of sale, no deed of conveyance, no lease, no consideration paid.
But there was a transfer of a valuable interest in property, wasn't there?
Actually, not to a new owner, and that's the distinction here, Judge.
And why does it have to be to a new owner,
Right, so,
as you understand design and our statutory scheme?
well, so one key distinction here, Your Honor, is this is not a direct deed of conveyance from one owner to another owner. This was a corporate transfer. These are entity level transactions. And entity level transactions are dealt with differently than, say, the direct deeds of conveyance that the court has dealt with previously.
No, what's the statutory basis for that assertion, if you could direct me to?
Okay, that's the Recordation of Economic Interests Act,
Mhm.
Your Honor. So let me say that VORNADO does not contest that a merger that there are merger certificates that may never constitute a transfer under the laws of the District of Columbia. A merger, like other forms of entity level transactions or transfers, and that's a loose use of that term, may constitute a deed, but only where counsel has said it does. And for that, we need to look at how counsel has addressed and expressly addressed entity level transactions, and that's under the Recordation of Economic Interests.
Counsel, I know I keep jumping in to interrupt, but is this really only controlled by what counsel says? When we have a statutory scheme that is designed to capture the value transferred here. And here there was value transferred. There were different entities, they were corporate entities. I understand that, but I am struggling to understand why, especially given the timing also of the transfers, no taxes should be owed. In Design Center and some of our other cases, we had various different structures. And I thought we had settled the general principle that the structure doesn't matter as much as the essence of what is being transferred.
Right, and the essence of what is being transferred requires one to look at what constitutes a deed. So we start with the proposition that a deed need not be recorded unless there's a deed. And so for there to be a deed, we look at the statute. And there was question as to whether a transfer of an economic interest constituted a deed. And counsel
let me stop you there because I'm a little bit confused. It seems to me that a title transferred here, not an economic interest. An economic interest transferred in 2006 when the independent third party sent the interest in M Street M2 over to VORNADO, right?
No, that was actually when there was a transfer of title. That title vested in VORNADO, and all transfer and recordation taxes were paid at the time that VORNADO initially secured its interest in the property. And the district does not dispute that. That's 399 in the joint appendix. The question here is what happened when there was a cleanup merger, a housekeeping merger. What happened is you have a subsidiary wholly owned by Vornado. And then after this transfer occurs and all transfer taxes are paid, they have to clean up their corporate structure. So to come back to the Chief Judge's question, was there a transfer of a valuable interest to a new owner? No. What there was an intra-corporate merger. And for that, we need to figure out if you're Vornado and you're doing an internal housekeeping merger, why would you even think that there is a deed here? You need to look at the statute, right? We look at the code. And how has counsel through the code addressed entity level transactions where there might be an effort to circumvent the payment of transfer and recordation taxes through entity level transactions? Well, the council did that through the REI Act. And so what the district is inviting the court to do is ignore the REI Act, ignore where council addressed statutorily entity level transfers that may constitute a deed. And if we actually look at the REI Act, which, frankly, the regulations there are so directly on point that any reasonable entity looking at those regulations would conclude the intra-corporate transfer of a wholly owned subsidiary, or I should say the intra-corporate merger of a wholly owned subsidiary to its parent does not even constitute a deed within the meaning of the district's deed and recordation tax act.
So what's your reaction to Cowan then? Remind me how you reconcile your position with Cowan, because Cowan was a single owner partnership that got dissolved. The same beneficial owner of the property still held it after the dissolution of the partnership. He was the only partner in it, and now he's got it as a person. And we said, well, that's a taxable transfer because you're transferring it from one legal owner partnership, sole proprietor partnership. I'm not sure if that's the right phrase, to just an individual. That seems like that could be described as a housekeeping matter, as an internal governance cleanup in the way that you're trying to describe this. And we said, well, it's a transfer between two distinct legal entities, and so it's taxable.
All right, so no question, those were two distinct legal entities. And the distinction there, of course, Cowan and the Columbia Realty Ventures case, both of which predated the REI Act, addressed entity level transactions, but they're different from an intra-corporate merger. And the court expressly acknowledged that, for example, in Cowan, there was no transfer of an interest in an economic entity by operation of law. Those were dissolutions of partnerships. And as a matter of District of Columbia law, to dissolve a partnership, you have to actually convey out by deed any assets of the partnership to the individual partners or to the recipients of the assets in order to constitute a dissolution. It's different in a merger. Mergers are different. And that's why under the REI Act and the regulations implementing the REI Act, the agency said that when we look at mergers, we have to figure out, was there actual change of ownership for purposes of an intra-company merger?
Well,
the owner before and after?
when we look at Columbia Realty, which was after the REI Act, are we supposed to be looking at the changes from one distinct legal entity to another? I know you're making the argument that this was a wholly owned subsidiary and the interest was transferred sort of in-house, but aren't they distinct legal entities, even though they're within a wholly owned, they're part of the conglomerate, for lack of a better word? Because I think you're making a distinction between different deed transfers, but these are distinct legal entities.
They are distinct legal entities. Here's the distinction, Your Honor, between.
They are.
Yes, they are distinct legal entities. And
But that is exactly, I guess, my point about them being distinct legal entities, going to the heart of what Columbia Realty was talking about and the need to assess the taxes when there's a transfer between those distinct legal entities.
To a new owner. All right, and that's the distinction here. Let me point the court to the DC municipal regulations, specifically section 523.1, which is under the regulations implementing the REI Act. And that's the provision that says that a transfer of a controlling interest from one entity to another, in which there is no change in ultimate ownership interest, shall not be subject to the REI Act. So by definition, there has to be a transfer from an entity to another. The fact that there are different entities does not ipso facto mean it's taxable under the REI Act. The REI Act and the implementing regulations point out that there are certain circumstances where an entity to entity transaction is not considered a deed for purposes of the Recordation Act, is not a transfer subject to tax. It's precisely this circumstance where there's a wholly owned subsidiary.
I thought what the REI Act was getting at is there are different ways to hold ownership interest. Sometimes it could be, you know, not by actually transferring the real property. Sometimes it can just be, you know, who owns stock in the entity. And it was meant to kind of get around a subterfuge where there was no actual transfer of the property between legal entities. But a controlling interest was transferred. They say, we want to tax that too. So it seems like you're taking what was meant to be a sword for taxation purposes. We want to get at those subterfuges and use it as a shield and say, and that also means even when there is a direct transfer of property, that's not taxable unless there was some change of controlling interest. And I don't know where you're getting that from the REI Act.
Well, Your Honor, I'll quibble with this notion.
Sure.
That there was a direct transfer of the property. There was not a direct transfer of the property. There was no deed of conveyance. There was a merger of a subsidiary into a whole.
What you're quibbling with is that the word direct shouldn't apply when something happens as a matter of law. Is that it?
No, it's that the REI Act was intended to address corporate level or entity level transactions where the council says there is a transfer of property, even if it occurs by operation of law. And so again, VORNADO is not staking out the position that none of those entity level transactions or no mergers would constitute a taxable transfer. It is that when you look at the implementing regulations of the REI Act, you see what did they address specifically in the context of this merger, the one that I'm raising with the court today.
So tell me a little more about this merger, because I'm still stuck on the property transferring between two distinct legal entities. And the REI Act looked at when the ownership of the real property changes by looking to the true ownership rather than the name of the entity moving the real property, right? So these legal entities that are distinct and different, one owned it and transferred it to another, and they then owned it.
Transfer it. No, it didn't transfer it. It engaged in a merger. The only evidence of anything that the district contends is a deed here is the certificate of merger. And so a merger is a creature of statute by which the merging company merged into the parent. Some of those may constitute a transfer to get around this issue of circumventing the law. But when we look at the implementing regulations of the REI Act, they addressed specifically, I'll refer the court to another entity to entity transaction. So the fact that they're different entities does not solve the problem for the district. If you look at DCMR 523.3.
Why doesn't it solve the problem for the district? Is your argument essentially that when you're looking at an entity to entity transfer here, that there would be a double taxation, or because somehow there was a prior tax of the same interest, or what is the reason that this doesn't constitute a taxable transaction?
Some mergers,
in your view, I know
would.
Okay.
Right. But what I'm saying is the first thing this court needs to do is it needs to wrestle with the application of the REI Act to get to the point that Judge Deal pointed, which is that the REI Act was intended to expand the scope of the district's taxing authority to get at efforts to circumvent through entity to entity types of transfers. A merger transaction is not a direct conveyance of title. It's a corporate level entity to entity statutory transaction. And VORNADO's view is that that type of merger may be taxable, but you have to look at the REI Act. And if you look at the REI Act and the implementing regulations,
So
again,
counsel, let me stop you there and ask you, as a result of the merger, the previous entity that EAT2, it ceased to exist, right?
yes,
So how is that transfer of title not the liquidated property issue raised in the statute and the regulations that would be taxable?
All right, so there are three regulations that apply here. I pointed the court out to one, but I'd like to just mention all three because I think they all evidence at least the agency's understanding that council did not intend to reach intra-corporate wholly owned subsidiary mergers, a very narrow subset. We're talking about a very limited subset of merger transactions. The first is DCMR section 523.3. And that is where the Office of Taxation and Revenue, the agency tasked with implementing this code, says the transfer of a controlling interest from a wholly owned subsidiary to its parent shall be considered a change of identity and not subject to the REI Act. So what does a transfer of a controlling interest mean in this context? Of course, you already have a wholly owned subsidiary already controlled. It can't be surplusage. I think what they understand there is, as they say, it's just a name change. There is no actual deed of title. There's no direct transfer. They've told us what that should be addressed, how that should be considered in the other regulations. I pointed out 523.1, a transfer of a controlling interest from one entity to another in which there is no change in ultimate ownership interest shall not be subject to the REI Act. There is no change in ultimate ownership interest.
Again, I guess my concern, the Superior Court said, I think the district is adhering to, is that's meant to capture controlling interests that do not actually involve transfers of land. If the real property doesn't actually change hands, but there's just a controlling interest that changes hands, we want to be able to tax that. That's what the REI Act is about. And I think what the Superior Court and the district are saying, it has nothing to do with this case because in 2006, E2 owns the property, 3040 M Street, I believe. And in 2007, VORNADO owns the property. We're not talking about the subterfuge of controlling interests that the REI Act was meant to pierce. We're talking about a transfer of the property itself. Now, your answer might be, well, there's not a deed unless it's because it happened by operation of law under a certificate of merger. But I'm not really sure I understand that answer. There's a piece of paper, there's a certificate of merger that affects a transfer of real property from E2 to VORNADO. So what am I getting wrong?
All right, two things. First of all, VORNADO at the time of the 2006 transaction was already the direct 100% corporate parent of E2. So the notion that VORNADO acquired some new interest in the property in 2007.
No, I'm not saying they acquired a new interest. They might have had an interest. They just didn't have the land. E2 had it.
All right, and the second part of that, Judge, is that the certificate of merger does not by itself convey title. That's not how mergers work. Mergers are statutory instruments. The title will vest by operation of law. The code.
I mean, that's such a funny answer to me. It vests by operation of law. So if I, let's say I leave a will that leaves all my property to the chief, and yeah, you're welcome. And I die, and that's not a transfer of property. The will couldn't be treated as a deed, as something that transfers the property to the chief because it happened by operation of law through, the law of wills and trusts and estates.
If council says it does.
If council,
meaning if the statute, if
the DC council
if DC council decides to enact the statute and say that will constitute a deed that must be recorded.
And why didn't the council say that when we've got a law that says any paper that conveys, transfers real property is a deed that's taxable? Why isn't the will that thing in that scenario? Why isn't that the paper that has transferred? I mean, why do they need to be more specific than that?
All right, because, well, the will is one step removed. And I think there would be an argument there that the will is the instrument of conveyance and that the will needs to be recorded. But that's actually not the way it works. And with a certificate of merger, it's not the way it works either. And so the issue here is it's no different
that when something causes it to happen, then it's happened like that. That's what 479013 is trying to get at. And it specifically uses that word vested that the Delaware law uses.
Agreed. But if we were to take such a broad approach, that would obviate the need for there to be an REI Act, to come back to Judge Deal's question. Why did the DC council Why is there a statute that addresses transfers of economic interests if the effect of any transfer of an economic interest was the same as a deed of conveyance? And that's because DC Council recognized that there was a gap in the law. And what they did is they said, we want to enact a statute that comprehensively addresses which types of entity level transactions get in the box, are subject to the Deed Recordation Act, because not all of them are. If you own real property in the district and that doesn't constitute more than 50% of your gross proceeds, or if it's not more than 80% of your assets, you never get in the box. You can merge, you can transfer to your heart's content. You're not in the box for an entity level transaction. So if we're going to upset the careful calibration of which entity level transactions are addressed, we ought to do it at least consistent with the regulations. And so VORNADO isn't here trying to say no mergers constitute transfers. We have to look at the REI Act. We can't ignore it as the district invites. And it's under those regulations that the Office of Taxation and Revenue has made abundantly clear. This is a name change. There's no new owner before or after this transaction. It's essentially the same as if there's no change in ultimate ownership. And I want to come back, Judge, forgive me, Judge Howard, I didn't answer your question about dissolution. Because again, there's a regulation 520.2, and it doesn't include the controlling interest language, which provides that a transfer to a parent in a complete liquidation of a wholly owned subsidiary that is subject to the Recordation of Economic Interests Act shall not be considered a transfer of an economic interest. So what they're saying there is that if you are a wholly owned subsidiary, again, a narrow slice, and you dissolve yourself into your parent, it's not taxable.
But the second sentence says, however, a liquidating distribution of the real property shall be a taxable transfer under the act. If that real property and dissolution of the entity distributes to the shareholder in the merger, the wholly owned parent, or the parent who wholly owns it, how's that not the liquidation?
That's Cowan, that's Columbia Realty Ventures, where there's a dissolution by distribution of the assets of the entity or real property to the individual shareholders. It's not what happened here. This is a merger by which all interests of the company that gets merged in are vested by operation of law in the surviving entity. May be taxable, but not in the context where you have a parent of a wholly owned subsidiary. The regulations make clear that's just a name change. And that's consistent with New York law, which was the model for this.
Mr. Bosch, thank you for your argument. I know you reserved some time for rebuttal, so unless my colleagues have any additional questions, we'll hear from you further on rebuttal. Thank you. Thank you. Mr. Love?
Excuse me. Good morning, Your Honor. May it please the court. I'd like to jump right in and try to address two issues. First, explain that there was a transfer to a new owner here. And second, why the REI Act is inapplicable. First, with regard to the new ownership. Yes, VORNADO owned 100% of the membership interests in E2 in 2006, but just because it held title to E2 at that time doesn't mean it held title to E2's property. As we explained in our brief, ownership of stock in a corporation doesn't make it the owner of the company. And the district's LLC law, as well as Delaware laws, as well as this court's precedents, say the same thing. If you look at DC Code 2980104A, it says an LLC is an entity distinct from its members. Delaware Code says a member has no interest in specific LLC property. And in both Cowan and Columbia Realty, the court recognized that a partnership holds and conveys property separately and distinctly from the individuals who hold an interest in the partnership. So here you have—
Would that be the same as with the corporate structure? Here we have a parent company that wholly owns one of its subsidiaries, E2. Is that analogous to a LLC and the shareholders?
No, the two entities here were both Delaware LLCs. So the statute that says that an LLC is just an entity distinct from its members is DC law. We have two Delaware LLCs. The Delaware code is even more direct. It says a member has no interest in specific LLC property. So I think that's a clear indication, along with the analogies, which I think are applicable here from Cowan and Columbia Realty, that you do have a transfer between two distinct legal entities.
So let me ask, let's say Delaware, where VORNADO and EAT2 are incorporated. Let's say Delaware has a statute that says, any parent corporation can park a property with a subsidiary for the exclusive purposes of conducting a reverse like-kind transaction, the fancy tax vehicle that was going on here. If within the 180 days permitted, that transaction fails, without any further action, that property will be absorbed into the parent corporation. Do you think that would be taxable? I've taken the paper out of it, is what I'm trying to do. I think the district's position is there is a certificate of merger. That's the paper that affected a transfer of property. I think what they're saying is, come on, this is really something that happened by operation of law. And yeah, there was a certificate of merger, but why would that matter? So if we just take the certificate of merger out of the equation and just say something that there's just a Delaware statute that says after 6 months, that property gets transferred to the parent if the reverse like-kind transaction fails, would you think that's taxable?
Well, I think yes. If there's
What's the deed?
Well, the deed would be that it would again be by operation of law that the.
You're losing your statutory hook, though. The deed is a written instrument, right? That's just. Don't get me wrong. This is a confusing thing about the districts. It is strange to me. I'm sure there is some historical reason for it, that what the district taxes are written instruments that convey and transfer property. But if you say, well, even without the written instrument, there's still a taxable transfer, I don't get where your statutory hook for that is.
Yeah, I agree. Even under the expansive reading, that you have no writing. But I think it elevates form over substance. If you have an actual transfer of real property, it's uncontested, it's from one entity to another.
I think the response is, well, maybe the district statutes elevate form over substance. In fact, the district has taken that position in its brief. It's taken a very formalistic view of it. You're not asking us to take sort of a realistic assessment of whether or not there's been a transfer of interest. You're saying, well, we need to be formalistic about this because there's a lot of different tax mechanisms that parties will deploy to evade taxes. And so we just have to take a really hardline rule that any transfer of property that's affected by a writing is taxable. I think the flip side of that position needs to be any transfer of property that is not affected by a writing is not taxable, but you seem to be fighting that.
Well, as I said, I conceded there's no writing there, but I still think that the focus of the district's tax and recordation statutes is to tax any transfer of property from one entity to another. And I understand the problem presented by the court's hypothetical.
So that brings me to a question on the record. I saw in the trial court record that the district seemed to take the position and concede that the 2006 transfer of interest, which was clearly from even as an agent, a separately owned entity to VORNADO, was not taxable. I couldn't pin down there why.
Well, I don't think that's what the counsel in the argument on the motion to dismiss was saying. I think if you read the transcript in its entirety, counsel was saying that there's no way to move the property out of EAT2 to VORNADO without subjecting it to recordation and transfer taxes. It's a transfer from one entity to another.
I understand that, but I understand that, but the REI Act would have directly applied to that, right? A complete transfer of interest from a separate legal entity with a separate owner to a new one, and the district didn't go for that.
That's right.
I'm trying to figure out why.
I'm sorry. Yes, I think as explained in the transcript, it was because that was seen as the second step of the failed 1031 like-kind exchange transaction. So it was seen as part of the same transaction that was taxed in 2006. But when you, more than a year later, you move the property out of E2 to Vornado, that was taxable because it was a transfer from one legal entity to another.
Would the district then have taken the stance that if in 2006, since you had this property secured by a loan that all Vornado could do is go after the property itself, if in 2006, instead of transferring that interest in E2, it would have taken advantage of something else from 47902, like a transfer and satisfaction of a secured debt or other obligation, that this transaction wouldn't ultimately have been taxable if Vornado had taken that route instead?
Well, if Vornado had left the property in E2, it would not be taxable. In 2006, as I said, it wasn't taxed because it was seen as a part of the failed like-kind exchange. But once the property moved out of E2 to Vornado, it was taxed as a transfer of the real property itself. And that's why.
Can I ask one other twist on that? Suppose all facts were the same in this scenario, except that E2, instead of merging into the wholly owned subsidiary, continued to operate separately within that structure. They transfer it.
It wouldn't matter if the property was transferred from E2 to Vornado, it would be taxable, whether or not E2 was dissolved or not.
Why, I guess, what is your counter argument to counsel's argument that that transfer from E2 into its wholly owned parent company and then dissolution of E2 is like essentially paying yourself, transferring it to yourself, and therefore there's no real other party to this transfer?
Well, because as they conceded, they're two distinct legal entities, and the fact that they owned the membership interest in E2 didn't mean that they held title to E2's property. As I said, referencing this court's precedents in Cowan, in Columbia Realty, the statute which provides that the property is held distinct from the membership interests. And, you know, the district's land records show the title was held in, still held in E2's name when they went to check the property records in 2019 when Vornado wanted to sell the property to a third party. So you do have a transfer of ownership from one entity to another. And the REI Act is inapplicable because the 2007 merger wasn't taxed as an economic interest transfer. Because here there was a transfer of the real property itself, as opposed to a transfer of a controlling interest in the property owning entity. I mean, the purpose of the act, as I think the court has pointed out, was to close a loophole. And the council explicitly recognized in the committee report that the law already applied to real property transfers as a part of a merger. So the economic interest tax prevents the circumvention of tax where control of the entity owning the real property rather than the real property itself is transferred. I mean, it's an anti-avoidance measure that backstops the regular tax. It doesn't replace it or create an exemption to it. And I think, it can't be used as a shield to avoid taxation here.
I'm interested in hearing more about the REI Act, but before going down that road, I just have a couple more questions about sort of how the district thinks this works. I take it you would agree that a name change to a corporation, just changing their formal name would not affect a transfer of all of its previously held properties to itself under the new name, right?
Right. I would think so.
And what about if they converted from a PLLC to an LLC? What if the corporate form changed? Is that a transfer?
I think I think that would fall under a conversion where, and which are exempt.
Which are exempt? Okay, those are my questions.
Well, your opposing counsel seems to suggest that this was a cleaning up of the structure of these entities, collapsing them into a single entity, which sounds a little bit like a conversion example that Judge Deal just mentioned. How was this different? This internal, to use counsel's word, cleaning up or restructuring?
Well, as I said, I mean, the bottom line is the property here was titled in the name of E2 in 2006. In 2007, as a result of the merger, the property was vested in the surviving entity, which is VORNADO. It's not, it cannot be, the district's tax schemes can't be circumvented by simply saying they parked the property in 2006 and unparked the property in 2007, or by saying they're just cleaning up the corporate structure.
What
They
about
chose to structure this deal, organize this deal, to have E2 acquire the property in order to try to take advantage of the federal tax benefit.
How do you square the language in the regulation, 523? I see counsel quoted from two different parts of it. I think it was in 523.1.
I don't think, I mean, again, the RE Act and its regulations, which implement the REI Act, are inapplicable because this wasn't an economic interest transfer. It wasn't taxed as an economic interest transfer. And so, yeah, it's using those regulations, which are totally inapplicable because they run to a transaction that did not occur here. And in any rate, the regulations, which I don't think VORNADO has ever addressed, 523.4 says that even if taxation is precluded under the REI Act, it's not, it's subject to any other act or law, which, is directly referencing the Recordation Act, which is what this transaction was taxed under as a conveyance from E2 to VORNADO. And
Can I just kind of take a step back? One aspect of VORNADO's argument is sort of how are we to know in 2007? The district, so far as I can tell, and I haven't seen the district pointing me to a counterexample, had not been taxing mergers of subsidiary into wholly owned subsidiary into the parent corporation. And there's sort of a fair notice / kind of a latches argument that's floating in the background. I don't know if they've ever really pinpointed either of those, but it was, when we did this transaction in 2006 and we set it up this way, we had no notice that the district was going to tax us. And the first time that we had notice of that was 12 years later in 2019, when they sort of alerted us that they wanted to tax that 2007 transaction. Now, I appreciate one point you might have is, well, in 2007, we didn't know about the merger. We only became aware of the transfer of the property in 2019. But on a more zoomed out level, I did not see the district responding, oh, actually, in fact, we had been taxing in other cases the mergers of wholly owned subsidiaries into the parent. I see a little bit of evidence of that in the legislative history from the REI Act itself. But I don't see the district coming up with any, we in fact had been doing this. I don't see anything that's really combating they're making this up 12 years too late.
There's a couple of things, Your Honor. First, it's their burden. And they had the opportunity to engage in discovery. They turned this around to say, we've not provided evidence of having previously transferred a transaction like this. But they had the opportunity to conduct discovery. They chose not to conduct discovery. and it's their burden. So I don't think the fact that there's no evidence in this record of this transaction or this type of transaction being taxed previously.
But I'm correct that the district has produced no evidence like that. I mean, the district could certainly have waved something in front of the court and said, here's some times that we've done that.
No, you're correct. The district did not, but again, it's their burden. But I would point the court to the fact that there are two cases from this court, both Columbia Realty, which held that an exchange of property between two legal entities is subject to recordation and transfer tax, although the participants in the two entities are similar or even identical. And we have the Cowan case, which found the transfer by operation of law taxable. I think both of those provide fair notice. I think the statutory scheme, which is very broad, provides fair notice. And I think the 1989 committee report says very clearly that mergers are subject to taxation and that this was a loophole simply designed to carry forward the intent of the pre-existing laws, which is to tax any real property transfer where there's a change in ownership. So I think there was, a number of things that provided fair notice that this transaction was subject to taxation. Finally, if I could, I just wanted to again sum up by saying that the taxability of the property transferred from one legal entity to another as a result of a merger is confirmed by the plain text of the recordation and transfer tax statutes, by legislative history, referencing the committee report of the REI Act, the implementing regulations, which we haven't referenced, which is 9 DCMR 520, I believe, 502.1A, which specifically says that mergers are subject to taxation, as well as this court's precedent, as I've referenced several times, Columbia Realty and Cowan. For these reasons, we would ask that the court affirm the Superior Court's decision in this case.
All right, thank you, Mr. Rowe.
Thank you.
Mr. Bosch, you reserved a few minutes for rebuttal.
I'll only take a few minutes. Thank you, Your Honor. As to the record, there is nothing in the record, and I want to dispute the notion that Cowan and Columbia Realty Ventures addressed merger cases. They didn't address mergers. They didn't address even transfers by operation of law. In fact, they say just the opposite. What happened there by operation of law was the dissolution of a partnership. And the court said to dissolve a partnership, the final step in the winding up process is the deed of conveyance of partnership property to the successors. So it's different from a merger. Those cases do not provide notice. The only way the district can get to its position is by asking this court, as it did again today, ignore the REI Act. But we know that the Office of Taxation and Revenue itself recognizes the REI Act as the source of its authority to tax mergers. Again, we're not saying that no mergers are taxable, but we're saying you have to look at the REI Act, because we know that by reference to section DCMR 9-520, which is helpfully under the title Mergers, Consolidations, and Liquidations. And that's under the implementing regulations of the REI Act. So again, there is no, as we know from the Expedia case, there is no need to defer to an agency's interpretation that contradicts its own regulations.
How do you interpret Regulation 523.4 that essentially says, this is a small, everything else is a small exception in this REI Act. And if you don't fit into one of these other categories squarely, then we're back to the prior existing statutory scheme for taxing these conveyances of real property interest.
Right. So two answers. One is that recall that what was the purpose behind the REI Act? It was to try to emulate the New York statute that addressed or taxed entities. And the New York regulators, the New York statute addresses specifically the context of a wholly owned subsidiary merging into its parent. And so if we're going to interpret that catch-all as manifesting legislative intent or even a regulatory interpretation to tax the wholly owned subsidiary into a parent merger, we have to disregard the specific legislative history And we have to disregard all those other regulations that address specifically the type of merger I'm discussing here.
So counsel, is it Vornado's position that 520.2, 523.1, et cetera, these regulations we're talking about were in existence in 2007 and you relied on them?
No, they weren't in existence in 2007. But that's not the limiting factor to it. That when we look at the taxation, we look at it at the time of the district's efforts to impose the tax. All right, I want to come back to one thing, and I think it was just Judge Howard, if the court will indulge me. There was some concern about what happened in 2006 and why would there have been no second tax due when this reverse like-kind exchange completed? And that's because each two is a nominal grantee. So ultimately it would end up, Vornado was going to be the beneficial owner of this property without any additional tax. The district does not dispute that fact. So this is not a tax avoidance scheme. It's not as if a new entity ever secured an interest in property that it didn't have previously, which is different from all of the other cases where you dissolve an entity. Coming back to the point, the individual shareholders don't own the assets, the partners don't own the assets, the members of an LLC don't own the assets. There was no distribution of the assets to the members of the LLC. There was no distribution. There was a merger of the company into the LLC. That's different. All right. Thank you, Your Honor.
All right, thank you. We thank both counsel for your arguments and briefs today and cases submitted. Thank you. All right, our second case this morning is DIVVER v. DC Department of Insurance, Securities and Banking. All right, counsel, are you ready to proceed?
Yes,
Good morning and may it please the court, Stuart Seraina on behalf of the petitioner, Danny DIVVER. If I could, I would like to reserve 2 minutes of my time.
Okay, thank you.
Thank you, Judge. There are essentially two issues before the court, Your Honor, and those are whether there is substantial evidence in the record that supports a finding of undue influence, and second, whether the award of restitution was appropriate in the circumstances of this case, assuming the undue influence was proven. The court, in reviewing this decision by the Commissioner of the Department of Insurance, Securities and Banking, must first find that there were findings of fact on each material contested issue. Second, that there is substantial evidence in the record to support each of the findings. And third, that the conclusions of law follow rationally. We contend that the Commissioner of the DISP failed each of these criteria. For a little bit of context before we get into the details of the issues, the overall situation involved in this case concerned a relationship between Mr. DIVVER and his client, Ms. Lynn, who that lasted 25 years. And over the course of that relationship, which began as a professional relationship, those two individuals became friends. That is undisputed in the record. Their relationship involved regular interactions over the course of the years, services provided by Mr. DIVVER, but also friendly relations that included Ms. Lynn vacationing with Mr. DIVVER's family and generally enjoying a close personal relationship with him. In fact, the relationship was so personal that by 2005, Ms. Lynn, unbeknownst to Mr. DIVVER, decided in consultation with her estate planning lawyer in a confidential consultation that had nothing to do with Mr. DIVVER, she decided to do the following: to designate Mr. DIVVER as her trustee, to make him the executor of her will, to give him power of attorney, a financial power of attorney, to give him a healthcare power of attorney. And finally,
not to quibble on a minor point, when you say unbeknownst to Mr. DIVVER, what's your basis for that?
testimony by Mr. Divver that he did not know at the time, and
The discredited testimony of Mr. Divver, right?
respectfully, I disagree, Your Honor.
But I mean, tell me, where was that credited?
Mr. Downs, who was the estate's planning lawyer, Thomas Downs, testified that his consultations with Ms. Thais-Lyn were confidential and that the role played by Mr. Divver in them was to make an initial introduction, to bring Ms. Thais-Lyn to his office, and then the consultation was confidential.
Pointing me to more testimony isn't going to tell me where it's credited. Where is that credited? I mean, Mr. Divver's testimony was broadly discredited by the commissioner. So I just was pointing me to somebody else. Was Mr. Downs credited on that point?
And Mr. Downs' testimony, this is a crucial fact about this record, Your Honor. Mr. Downs' testimony was credited as to basic facts concerning the date on which he had meetings, the directions that he was given by Ms. by Ms. Thais-Lyn, which are critical, but was simply ignored by the commissioner in her findings of fact and conclusions of law. In the final decision in order. There is simply the commissioner and underlying hearing officer simply ignored the testimony, but it is in the record and it is cited in our briefs where Mr. Downs, who has never been disciplined in connection with his practice.
Well, I'm sorry, counsel. When we're talking about credibility findings, I'm not sure I would agree that there's any basis to say that the commissioner ignored any of the testimony. I think on the record that comes to us, the commissioner specifically and explicitly discredited Mr. Divver's testimony. And she's not, or the commissioner was not required to say something about every person's testimony. I mean, it's all in the record. We know that she discredited Mr. Divver's testimony, and there were reasons stated on the record for why that was done, and that she credited other testimony. And so that's the record as it comes to us. And so if Mr. Divver's testimony that he didn't know that he was being made the beneficiary, the trustee, the executor for his client, who he had fiduciary responsibility for, then that's the record as it stands before us, isn't it?
Let me clarify a couple of things, Your Honor. And Your Honor is quite correct. And there's a reason why in my argument to this court, I am not emphasizing the testimony of Mr. Divver, because I recognize I respectfully disagree with the commissioner's findings, but I recognize that those are the findings. Okay. I'm asking the court to rather credit. I am not asserting that the commissioner ignored Mr. Divver's testimony, rather that she ignored Mr. Downs' testimony. Mr. Downs is an attorney in good standing, okay, and was at the time of this. He testified to the court. The commissioner's findings and the final decision in order concerning Mr. Downs are between pages 24 and 26 of the commissioner's final decision in order.
But I just want to stop you as a legal matter, because, you know, it's one thing to say we don't have sufficient credibility findings from the commissioner and therefore you court need to remand. It's a very different thing to say you court in the first instance should be crediting Mr. Downs when he was not credited below, which is something we definitely cannot do. Okay, so when you're leaning on Mr. Downs' testimony as being a basis for saying if credited, that would mean there's insufficient evidence of undue influence. Like the simple response is wasn't credited. You might say, well, it should have been, or there weren't expressed credibility findings that need to be remanded for further consideration. But you can't ask us to credit those. That's not a thing that we do.
Respectfully, Judge Steele, what I'm asking this court to do is to recognize that Mr. Downs' testimony was credited in certain respects and unimpeached in others. And all of that's in the record. But what we have in the final decision in order as findings and as part of its rationale is an absence of consideration of the critical parts of Mr. Downs' testimony. At the heart of this case, as it relates to undue influence, is the simple question whether Ms. Thais-Lyn's will was overborne, whether such influence was exercised over her that she essentially could not express her own will. And what you have is an attorney in good standing who averred under oath that he represented that client in confidence, that he made assessments about whether these were her true wishes, that he interacted with her personally and was convinced of her, that she was making her own decisions. We have separate record evidence that is consistent with and supports that.
Yeah, is your argument that, and we are required as a matter of law to find that that is credible testimony, or is your argument that there needs to be further findings on that?
Right. My argument, Your Honor, would be that the
No,
court,
yeah. So I mean, the other way, the way that it could be phrased would be no rational fact finder could fail to credit Mr. Downs on this record. Is that the argument that you're making?
I would say that no rational fact finder could come to the conclusions reached in the decision in order, the final decision in order, without addressing the credibility of Mr. Downs on these critical points, rather than on the tangential points over which there's really no dispute.
That's quite different than, I'm sorry, Judge Howard, please.
So you're challenging the weight of the evidence.
I am challenging the rationality of the evidence. That is the rationality of the decision which failed to incorporate evidence critical to the decision of finding undue influence or not. Without addressing that information, then an attorney in good standing, a reputable attorney practiced in estates law his entire career, et cetera, would have an interaction with a client and would write a will and would accept her will as a valid will. That in combination with the other, the medical evidence in particular in this case, which is also undisputed.
Well,
I'm sorry.
we do have testimony from an expert witness, the psychiatrist or psychologist who gave testimony which was credited by the commissioner, that Ms. I was getting ready to say Ms. Fevers, but I know that's not right. Ms. Lewin, no, not Ms. Lewin.
Mr. Lynn,
Mr. Lynn, excuse me, was a victim of undue influence. And this credible expert witness explained the factors why, and that in his assessment, she satisfied those factors. And why isn't the commissioner's crediting of that expert witness testimony sufficient for us to determine that there was undue influence here?
I would invite the court to simply read that testimony, which is so logically disjointed and so unrelated to the facts.
We have read this testimony in the record.
I'm sure Your Honor.
That's why I'm asking why that. So what would you be suggesting, that testimony which was credited isn't credible again, or what is our recourse at this stage with the record that is presented to us here? What are you requesting?
I think I'm challenging here the rational connection between the facts found. It's undisputed that Mr. Dr. Lichtenberg, excuse me, a psychologist, that Dr. Lichtenberg testified to what he did. I'm sure he was sincere. Okay, I'm not challenging his credibility in that respect. What I'm challenging is the logical relationship between the factual observations that he made. Actually, he didn't make them. He never interacted personally with Mr. Lynn. This was based on some hearsay testimony, some things he read. Some of it was admissible, some of it was not, and that's okay. What I'm challenging is the rational relationship between that information and the sweeping conclusions that he reached concerning it.
So what's the remedy?
The remedy, I think, Your Honor, is a remand with instructions for more specific findings on the key missing elements, how Mr. Downs' testimony relates to this overall picture, and whether Dr. Lichtenberg's conclusions follow from the facts that were found.
Did the commissioner apply the appropriate legal standard here, aside from the facts that were taken into consideration?
No, Your Honor. And
tell us why.
Because the commissioner relied on, strangely, Dr. Lichtenberg's opinion about what undue influence is, which I respect as a matter for a psychologist, but it does not have anything to do with District of Columbia law on this point. And this point is covered in the briefs. I won't belabor it, but
I think it's worth mentioning to the court what you define, what you believe is the proper legal standard for undue influence that should have been applied, and whether or not it was in this instance.
Yes, Your Judge. The test comes from the In re Ingersoll Trust case, which is at 958 second at 672. And the test is as following. The undue influence requires proof of physical or moral coercion that forces the testator to exercise the judgment of another rather than her own. And importantly, where there is a will or some estate planning instrument that memorializes the testator's intentions, overcoming that, which is what's required in this case, requires clear and convincing evidence. And the commissioner didn't apply these standards. She applied some rather loose language that was used by Dr. Lichtenberg. And so on that basis as well, I would say that the commissioner's final opinion in order was, final conclusions in order was unfounded and should be remanded for them to reevaluate.
Where are you getting the clear and convincing evidence standard from? And did you make that argument before the commissioner?
I believe that I made that argument before the commissioner. I believe it was in our, I'm certain it was in our briefs, nearly certain, Your Honor.
I mean, I guess my question is that, are you getting that rule from probate cases where it's a question of, you know, whether or not they're going to administer the will, or are you getting that from undue influence cases?
They're often, undue influence, of course, occurs regularly in probate, but the direct answer is from probate cases litigating undue influence.
Mm-hmm.
Would now be a helpful time for me to switch to restitution, or would the court have more questions about undue influence?
You can switch to
Thank you.
restitution.
Thank you, Your Honor. Mr. DIVVER believes, of course, that no restitution order should issue in this case because of the absence of undue influence. But should the court determine otherwise, then the question becomes, and I think that to its credit, the DISB acknowledges this, that the question is whether this award is restitutionary in nature. Restitution is a way to recompense or pay back wrongfully taken money. In this circumstance,
Or money that you receive that you're not entitled to. Rightfully under the law. So two sides to restitution, I think.
I agree, Your Honor, but the latter, the one identified by Your Honor, has to do with some wrongful action. And that wrongful action must be with respect to someone. So the taking must be from someone who is entitled to have that money. In this situation, there are two potential candidates for who this money may have been taken from. The obvious first one is Ms. Lynn. Was this money wrongfully taken from her? We have a 2014 estate plan under advice of counsel at a time when all of her medical providers averred that she was perfectly capable of looking out for herself, in which she designated that her estate, and in particular that part of her annuity, the death benefit, would go to Mr. DIVVER. She didn't lose that money during her lifetime. She had the benefit of the annuity during her lifetime, which enabled her to live where she did. Accordingly, I would say that there's nothing wrongful about that taking with respect to her. Second potential candidate for this is her sister, Ms. Lewin, who is the previous beneficiary.
We better pause there, though. I mean, because I know what you're going to say next.
Yeah.
Because when you say respectfully, there's nothing wrong with the taking as to her, that seems to just go back to your first argument about undue influence. If there is undue influence, why isn't there a wrongful taking from the estate that restitution is due to?
I think that's a valid point, Judge too.
Okay.
And which really brings me to the second point. Once we get past the question of whether there's any wrongful taking, and I'll take Your Honor's point that it's not worth belaboring the point as it relates to Ms. Lewin, but we would certainly say that she wasn't harmed either. Is this restitutionary in nature? What amount, if Ms. Lynn, if her estate was manipulated, what is the appropriate context in which that issue should have been resolved? It would have been in probate court. And so what we have here is the DISB, in essence, the government of the District of Columbia, coming in years after it would be too late to probate this matter. And rather than someone who is standing to litigate a probate issue, it's the DISB coming in and saying, no, we as the government know better where this money should go.
Well, but you know, I think, counsel, that sort of gets to the heart of this issue, which you haven't actually addressed in your argument. I mean, the concern that underlies this dispute and the reason that the government is coming in is because what you portray as a personal relationship that just naturally evolved between Mr. DIVVER and Mr. Lynn goes against most professional norms of what broker, insurance broker, fiduciary does and has this type of relationship with a client. It's unusual, it's highly unusual that an insurance broker who sells you multiple $250,000 and more policies repeatedly over a series of years then becomes the beneficiary of those policies and then gets to administer and probate them. So I understand in your narrative that you describe it as a perfectly normal situation, and it's not. And that's why the insurance company has come in to look into what happened here and why. So it is not usual that there becomes such a close relationship that you leave all your worldly possessions and she had some illnesses, some of which go to potentially her mental competency and capability, leaving everything to your fiduciary who sold it to you in the first place as a fiduciary agent, not as your friend or personal family member. So this case has some very unusual circumstances that warranted the posture that it's in with the insurance agency. And I'm sure we'll hear more from them, and then you'll have an opportunity on rebuttal to address those highly unusual aspects of this case.
Thank you. Okay.
Good morning. May it please the court, Thais-Lyn for the Department of Insurance, Securities and Banking. I don't think there's any question that what occurred here was in fact fraud through undue influence. Mr. DIVVER brokered an annuity transaction that inflated the security's value to over $500,000, and then he maneuvered himself to become the beneficiary of the annuity. He purposefully concealed his position as fiduciary of his elderly and infirm client, and he also lied about being the beneficiary of the estate. And of course, he has conceded that he drained $76,000 from Ms. DeLynne's bank account days after learning that she had become comatose. So there is ample evidence in this record of undue influence. I'll just respond to a few points that were discussed here this morning. In the first instance, I'm a little surprised to hear such emphasis on the testimony of Mr. Downs, because I think that was largely forfeited in the opening brief.
Can I just to direct you to where I'm most interested? It's the question of whether or not the commissioner applied the correct legal test. So here's what the commissioner says. It says, well, A, they cite to a presumption in favor of a fiduciary having exerted undue influence, which I think you agree does not exist in the district's law. Now you have some responses to that, which I understand, but let's get to the legal analysis. The general rule regarding undue influence is when a dominant party or influential party on one side may exert influence against a dependent or submissive one on the other. The dominant party's conduct counts as undue influence when he uses his position to sway the judgment by advice or suggestion, or even by implication. They say, well, that's not the law in the district. There's no presumption that a fiduciary, there's no presumption A, and B, advice or suggestion is quite far afield from coercion, which is what the district recognizes to be undue influence. Your response in your brief is, no, that is the law of the district with no citation. So is your position that a fiduciary who by advice or suggestion influences a decision has committed undue influence?
So there's a few things to unpack in your question. So first of all, I think, yes, I think the commissioner, if anything, was applying a narrower standard than what district law encompasses. And so on page 29 of our brief, we cite to the Weir decision. There's also the Mears and Ross decision that undue influence, as this court has recognized, is influence gained by improper means of any kind. But
which according to the commissioner includes advice or suggestion. Where do you see support for that in the district's law? Why is advice or suggestion improper means?
I think it can be, and it can be one type of improper means. It can be one tool used to exert moral coercion over somebody in here who was in her 80s and suffering from undiagnosed pancreatic cancer. But to your other point, Judge Steele, I would disagree that the commissioner incorrectly applied a presumption of undue influence. I understand that the commissioner recited as part of his factual recital of what the expert testified to. The expert wrongly stated that there was a presumption of undue influence under district law, but that presumption was not actually applied.
Was it later disavowed?
There's nothing in the legal analysis section.
There's almost nothing in the legal analysis, period. You know, this is a one paragraph of legal analysis and a few sentences saying undue influence is satisfied here. The one paragraph of legal analysis includes that advice or suggestion of a fiduciary qualifies as undue influence. And you're telling me that's right, but I don't see you pointing to anything that says it is. Mears, Ingersoll, and Ross all talk about rising to the level of coercion. That's not a standard that's ever articulated by the commissioner. It's not a standard that's articulated by the expert, who is, seems to be broadly credited by the commissioner. That's a big concern. Ross, Ingersoll, and Mears have much starker facts than this. I mean, you've got Ross, you've got somebody who's bedbound, you've got roofers who have just come into her life for a couple of months, who are taking out loans against her house. And here you've got a 25-year friend. Now, it's true, things really accelerated in the final year of that relationship, so that I think it's true, one could find undue influence, but you would need to apply the correct legal test of coercion, not advice or suggestion, in order to reach that conclusion.
There's absolutely evidence of coercion here. And I'm really surprised, Judge Gill, to hear that the notion that the facts here are much less stark than the other cases under district law. We have a situation here where a broker-dealer agent, again, upon learning that his client, supposedly friend, had fallen into a coma, drove to the bank and took out $76,000, including wiring $20,000 to his son's account.
This is somebody who's been in the will for over a decade, right? He's had some money bequeathed to him beginning in 2005, is given by Ms. Dellin, of sound mind at that time. I don't think there's any dispute. Power of attorney over her legal affairs or financial affairs, I forget. Don't get me wrong. I think I've said, I think that's enough evidence of undue influence. What concerns me is you telling me that it's coercion and me thinking it might be coercion is not the same thing as the commissioner finding that it's coercion versus applying an incorrect legal test that persuading somebody, advising them, amounts to undue influence. Like I'm still waiting for, point me to the case where we say the advice of a fiduciary is undue influence in the district.
Well, it's not just that, Your Honor. And to be clear, the court isn't wed to the commissioner's exact explanation in the record. The question on substantial evidence review is whether there's substantial evidence to support the legal conclusion that there was an device, artificer scheme to defraud through undue influence. And the record absolutely
they've got to apply the correct legal test. We don't say if there's substantial evidence to support a finding under a correct legal test, we don't care if the agency applied the wrong legal test, do we?
Well, Judge Deal, if the court has concerns, the court could certainly remand this to the agency to take a look at and clarify the application of this court's undue influence case law. But this court has been very clear. It's a totality of these circumstances inquiry. It's also an inquiry where this court has said there's much less that needs to be shown when there's a relationship of confidence, and something like this occurs here. And the record shows not only that Mr. DIVVER drove Ms. Lynn to the bank to replace her sister's joint overhead of her bank account, and then took that money from her after she fell ill. There's evidence of purposeful concealment here. His testimony that he knew, but he did not report to his employer, his change in position. Testimony from Mr. Levine also, who described his evasive nature after Ms. Lynn's death. And of course, he also was not just evasive, but flat out lied about whether he become the beneficiary to her estate. So there's clear evidence here of purposeful concealment. That's just one of several elements that the agency's expert testified to, that we see in a situation where undue influence is being exerted over an elderly, infirm individual. It is often exceedingly difficult to marshal direct evidence of undue influence, but I think it's quite apparent here from the record, in addition to the circumstantial evidence. And to your earlier point, Judge Howard, I think my friend on the other side is precisely asking this court to reweigh the evidence. But that is not something, Judge Steele, as you pointed out, that this court is in a position to do on appeal. Moreover, there is no arbitrary and capricious challenge presented here on appeal in terms of the commissioner's explanation of weighing the evidence. It is a challenge to whether there's substantial evidence in the record, and under that well-accepted standard, there can be a quantum of contrary evidence in the record, but I think it's quite fair to say that the balance of the evidence more than supports the conclusion that undue influence was exerted here by Mr. DIVVER over Ms. Lyn.
But as a court, we've traditionally held agencies to what they say, right? And so much in the way that we can't go back and reweigh the evidence, we can't fill in the calculus for the agency, can we, when they've just got the legal standard wrong? I know this is essentially the same question you've been asked already, but it seems like that kind of look cuts both ways, at least as far as our case law has gone in the past. It's something that reminds me as being kind of similar to the lurking in the record doctrine. The agency didn't come forth and say, you violated this exact right standard. They said you violated this potentially wrong standard. And while we could clean up behind a general jurisdiction court, we generally do not do that for agencies, do we?
Well, again, I'm having a hard time, I guess, understanding the court's concern here, because when it comes to the undue influence test, influence gained by improper means, unduly swaying an individual's judgment through coercion, I'm having a hard time seeing why the advice of a financial advisor, a fiduciary, somebody in a trusted position as a confidential advisor, why that individual giving advice about where to place an individual's money in a security, and again, inflating that asset to over $500,000, and then giving advice that further advice about how to revise her estate planning portfolio. I'm having a hard time seeing how in the totality
That sounds like a lot more than a paragraph, right? Did the agency extrapolate on all that and its conclusions of law?
I mean, the agency stated that it was basing its conclusion on the testimony at the hearing and the evidence in the record. And there is, as we've been discussing this morning, I think much more than even substantial evidence in the record of undue influence.
I mean, let's just put it in stark terms. If I go and speak with a financial advisor who advises me to put money in an annuity, that would satisfy the commissioner's test for exerting undue influence on me. It's somebody in a fiduciary capacity who, by advice or suggestion, has prompted me to act. Do you think that's undue influence?
I think there's a situation where there wouldn't be substantial evidence of undue influence there. I mean, if the facts are strictly speaking that there's a financial advisor and there's none of the other facts that we have here in this record.
Yeah, I mean, you keep talking about the facts. I appreciate the facts, but what I'm asking is if the commissioner applied an erroneous legal test, and what the legal test is, according to the commissioner, is the dominant party's conduct counts as undue influence when he uses his position to sway the judgment of the other by advice or suggestion, or even by implication. That's just about every fiduciary relationship with another human being. You go to them for advice, they advise you, sways your judgment. Always undue influence?
I don't think it's always undue influence, but it definitely can amount to undue influence. And on the facts here, I mean, we can't ignore the facts that you have here somebody who was supposed to be
But I don't think we're quibbling with the facts. And in fact, I think we're suggesting that the facts might be sufficient under the correct legal standard for undue influence. But undue influence is ultimately a legal determination. And if you're applying an incorrect legal standard, I mean, the facts have to be put into a framework. And what we're concerned about is whether the legal framework that is mentioned in this record, referred to by the commissioner, is the correct legal framework. And the language doesn't seem to suggest that it is the same language that we've used in our case law.
And I understand the concern, and perhaps this is a better way of describing things. I think if there's a totality of the circumstance test where at least 5 different ways of committing undue influence have been explicitly enumerated in district law, and the agency
Well,
says that one of those.
That's a good point there. So which ways did the agency say undue influence could be committed that are consistent with some of our case law and precedents?
Well, to the concern about advice, that is one. I mean, I think it's quite clear that that's just one manner of using of Mr. DIVVER using his position in order to sway Ms. DeLynne's judgment. It's one type of tool in the totality of the circumstances of all the things that he could have done.
One aspect of the legal standard that we have applied in our prior case law
I
for
think
finding
it's-
undue influence? And if so, tell us which case or where that comes from.
Sure, I think it's sufficient but not necessary, maybe, to put it another way. And I know that Judge Deal said that some of the facts of these other cases were.
Can I stop? I think what we're asking for is there a case where we use language similar to the language that the medical expert, the psychologist expert used in this case, which seems to be the language and the test that the commissioner applied?
So to finish my earlier thought, I believe the Ross case is maybe one of the best. And I do think that the case confronts a very similar situation, and you have individuals there who had taken advantage of an individual who had medical concerns and who was quite isolated and who was relying on these individuals as trusted confidential advisors, who these individuals also attempted to conceal their actions of what they were doing. And the court in the Ross case repeated its instruction from Mears that it generally takes much less in that situation, where someone, not even talking about a formal fiduciary, but where somebody has just has simply a confidential relationship that exists between the parties. And so I think, as we explained in our brief, that situation is very similar, and it's again a totality of the circumstances inquiry. If the commissioner applied a narrower test than what this court looks at in the totality, I think that.
I mean, the totality of the circumstances going to what question, though? I mean, you can say it's totality of the circumstances, but the question is, what do the totality of circumstances show? And if they show coercion enough to overcome the free agency of an individual, well, then that satisfies the test for undue influence under our case law. If it is the totality of the circumstances show that he advised her to do something that's beneficial toward him, and she complied of sound mind, that would not satisfy our cases under undue influence. But it would seem to satisfy the commissioner's standard, and that's what's bothering me. The commissioner's standard is like, take the following facts. Assume Ms. Dillon really liked Mr. DIVVER. Toward the end of her life, she said, you know what, you've been the only one who's been here for me in the last year when I've been sick. You know, Mr. Levine, he's bailed on me since he had a kid. My other friends, they don't care about me anymore. My sister doesn't need the help, and her kids sure don't need the help. They've got a lot of money. And Mr. DIVVER says, you know, well, I could use the money. You should consider making me your sole beneficiary. And she says, you know what? I think that's a great idea. I'm going to do it. Do you think that's undue influence?
I think it could be, depending on the situation where you have an individual.
You think that amounts to coercion that overcomes the free agency of another individual?
Does that amount to coercion? Just the simple statement?
Advice or suggestion, yeah, or implication, as the commissioner said, was enough.
Yes, it could be one part of a scheme to defraud where the seeds could have been planted 10 years earlier.
I'm not talking about one part. I'm talking about, is that enough?
I guess, and just respectfully, I'm having a hard time seeing from this court's precedent why there is this impulse to hyper-focus on, for example, one fact there, a statement.
I'm not trying to focus on one fact. What I'm trying to focus on is that we've got a legal test that says if he advised or suggested that she do this. that's enough to amount to undue coercion, both because of what I think is a mistaken presumption under the law. And again, I'm dealing with what amounts to a single paragraph of legal analysis here. And they state that test that does not sound at all like the test that we have articulated, that undue influence consists of physical or moral coercion that forces the testator to exercise the judgment of another rather than their own. That does not sound like somebody who's acting on the advice or suggestion of otherwise free will of a fiduciary, which is what the commissioner's test is. I don't know how I can put it any more starkly than that.
I mean, I think I respectfully disagree because I think I can
What part do you disagree with?
I disagree that someone who's supposed to be in a position as a fiduciary giving advice to an elderly and infirm individual who's been isolated from her friends and family in an environment where she's mostly relying on that individual. I disagree that when that individual says, hey, why don't we put $400,000 into your annuity so that it's worth over $500,000, and why don't I, and he doesn't even tell her, but he calls the estate planning attorney's office to say, there's going to need to be some changes here. He also implicitly signals he understands the medical condition that she's in by stating that this may have to be a DC visit. He has initiated, taken those active steps towards financial procurement. And he also drives her to the bank to replace her sister as beneficiary of the bank account. So yes, I think in that situation, giving advice, hey, why don't we go to the bank? Yes, I think that absolutely amounts to coercion and leads to a situation where he has taken advantage of her such that she is not exercising her judgment any longer, but the judgment of somebody who is supposed to be her fiduciary. So,
Did you want to address restitution in your?
Yes, I'd be happy to address the restitution issue. I think not only is there a remaining financial injury in this case, Ms. Thais-Lyn and her estate, they have been defrauded of $500,000 in violation of district securities laws. They have not yet been made whole, nor will they be made whole without the department's restitution award. And the restitution award is a clear exercise of the agency's explicit statutory authority for at least 3 reasons. The plain text of the settlement agreement, also precedent, including Supreme Court precedent in the Waffle House case, and then applicable principles of equity as well. And
Well, you know, our statutory scheme here does talk about restitution. I guess where it's not quite as explicit is restitution where other parties have already reached an agreement about how to settle the funds in dispute. And so this is actually third party, not part of that settlement agreement. How do we make that leap from the typical type of restitution that would be ordered between 2 parties?
Right. So I think we can look to 3 things, and then I'll walk through these 3 points in turn. First, looking at the plain language of the settlement agreement, this release claims that Ms. Lewin had against Mr. DIVVER, the claim specifically being entitlement to the Transamerica annuity, but she did not give up her right to receive equitable restitutionary relief in a totally separate administrative regulatory proceeding by the government to ensure a licensee has complied with licensee duties. And I'll also note he doesn't challenge the vast majority of the violations with which he was charged under the agency's authority. So these are very different proceedings on different claims and by individuals who are very differently situated. The government here wearing its hat both as regulator and then also as protector of consumers and the public interests. And so the plain language of the settlement agreement doesn't even purport to somehow reach or cut off the agency's statutory authority. And even if it had, it could not do so under governing Supreme Court precedent. So I'm sure the court is familiar with the Waffle House case that was raised in the reply brief. Waffle House importantly stands for the proposition that a private contract can't require an agency to involuntarily relinquish its statutory authority. And the fact that a private contract can't deprive an agency of its enforcement authority is further underscored by the circuit court cases addressing this issue in the res judicata context. And we don't have the res judicata problem here because this is simply a private contract. It was never converted to a judgment that's clearly reflected in the public docket to the interpleader action. So we just have a private contract here that doesn't bind a non-party. And as the circuit courts have said, including the 11th Circuit and the Herman case that we cite in our brief, in the ERISA context, for example, there's again a judgment, but even there's no identity of interest between a private litigant and a government agency carrying out its statutory mandate to enforce the law. And there's, of course, a manifestly public purpose to these enforcement actions. And
Well,
the
in
Supreme,
council, this is a regular part of the scheme in DC, right?
that's
We make the Office of Human Rights party to even the settlement negotiations for private plaintiffs in front of them, the buildings department, licensing enforcement, et cetera. They do the housing violations, and the person who is the actual victim would have to intervene if they want any interest, and otherwise they've got their superior court case. So this is just a very normal thing we do, right?
that's right. And so Supreme Court precedent squarely addresses this issue in addition to, again, the circuit court cases we cite in our brief. And I think there would be some very negative consequences to allowing the contract to trump the statute in the first place, because it would go against the legislature's carefully constructed enforcement scheme. And in practical terms, that means frustrating the department's ability to go after individuals who engage in fraud. And so, Waffle House, we do acknowledge at the end of that opinion speaks of principles of res judicata, mootness, and mitigations, or some potentially other applicable equitable principles that could apply. But there is a rule against double recovery, but there hasn't been double recovery here. This restitution award would simply operate to make Ms. Dellin and her descendants whole in the first place, and nor has Mr. Diver been penalized doubly as a result of the restitution award, given that the evidence in the record shows that he actually defrauded Ms. Dellin and her estate out of much more than just the $230,000 stemming from the Transamerica annuity. So I think the court, looking at the plain language of the settlement agreement, the Waffle House decision and principles of equity, should have no problem affirming the agency's statutory authority here.
All right, thank you, counsel, for your argument today. Mr. Seraina, you have reserved some time for rebuttal.
Yes, Your Honor, I'll be brief. Coming back, Chief Judge, to your point about these circumstances being highly unusual, I didn't mean by the tone of my voice to normalize them in any way. Your Honor is absolutely correct. It was an unusual circumstance. Now, some of that unusual character was because of the unusual nature of the relationships. Most insurance brokers do not have personal relationships with their clients that span 25 years, et cetera. However, I will readily acknowledge that what occurred in this situation was problematic from a couple of standpoints. FINRA was not happy about it, and they conducted a very careful investigation. And as a result of that, they entered a sanction that was a $10,000 fine and a 9-month suspension from the industry. No problem with that. Mr. Diver recognized the validity of that enforcement action. Second, Sage Point, his employer, did have rules against this behavior. However, there were exceptions, and the facts of this case were very close to the articulated exception. So I would respectfully offer, Your Honor, that although unusual and problematic from FINRA's point of view, this was not a broadly unlawful undertaking. The existence of a relationship and the kinds of interactions they had were not problematic. There is no evidence in this record of lack of suitability. We heard a lot of argument about money going into the annuity, as if the only purpose of that could have been to pad Mr. Diver's pockets at some time in the future when, in consultation with her lawyer, she would give him, make him the death beneficiary. There's no evidence that such consultation between Diver and the lawyer ever occurred, but the investment, the annuity, was entirely suitable. Mr. Diver testified in detail about it. It would have enabled Ms. Dellin to live indefinitely. She could have still.
When you say no evidence, part of the difficulty with these cases is the person who's in the best position to give evidence against your client is dead. So, and so when the commissioner discredits just about everything that your client says, and you look at the background circumstances, and we have said circumstantial evidence is almost always necessary in undue influence cases. Those circumstances include keeping the power of attorney hidden in 2005, all that, and taking $76,000 out of her account before she died, setting up the arrangement with Mr. Downs to revise her will.
I'd respectfully disagree with some of the details of the points Your Honor offered, and I can go through them if it would be helpful. But if I misspoke, I apologize. What I meant to say is there's no evidence of lack of suitability. The investments, the annuity in particular, was entirely appropriate. And so any insinuation that that was part of a scheme, there's no evidence to suggest that that was not helpful for Ms. DeLynn. It would have enabled her to live indefinitely. She could be alive at age 120. And in a nursing home, and she would still be cared for by that annuity. So that's the first point. Concerning Your Honors, some of the other points, just very briefly, Mr. DIVVER corrected himself on the stand. At one point, he recalled that, oh, he did set up that meeting. And of course, there's no dispute, but that he drove her. Ms. DeLynn didn't have a car. She didn't drive. So some of the things that the DISP thinks are very incriminating, very inappropriate are, from Mr. DIVVER's standpoint, very commonplace. But Your Honor is right. The hearing officer made the proposed findings she did, and the commissioner embraced those, and we are stuck with some of those. A couple more points real briefly, Your Honors. I would just direct the court, I'm sure it's already reviewed it, to the Waffle House case, which specifically carves out a situation in which there was a settlement and identifies the fact that some of that money would perhaps reduce the amount of restitution that may be appropriate. And then also on the Ross case, this is very, very far afield from the circumstance. I'm surprised that the DISP would offer it as an analog here. In that situation, the individual was nearly blind and bedbound. She was totally dependent on others. And she had a history of giving her estate to caregivers, and the party in question there was a roofing contractor who had known her for only a few months. Very, very different facts from this case. I think with that, unless the court has any other questions, I would submit.
All right, thank you. We'd like to thank both counsel for your briefs and for your arguments today. Thank you.
All right.